Good afternoon, everybody. So we are happy very much to see all you here. We think that the question not about how much we are here, but how intensive we are here. So I would encourage everybody of you to participate very hardly in the discussions and ask questions. Ask questions which you will have a chance after all presentations. We'll have an order that everybody from our panel will give presentations, and then we will move to the discussions. So this is procedure, and we have section which starts by Karolina Mitskutė. It's from Vilnius University. So I would like to hear her presentation related to our law. So please, the floor is yours.
It's actually a great privilege to be starting this section, and I feel that we already started to get to know each other, right? So just a formal introduction, I'm a second-year PhD student, Karolina, right here from Vilnius University, and obviously my interests lie within the gamut of the WTO law, the World Trade Organization law, and in the context of e-commerce and how digital trade is growing rapidly, I would suggest restating the organization's role in regulating e-commerce internationally, and more particularly, I would like to, he's trying to tell me something. I don't want to do that. Can I refuse the microphone? I do not wish to do this. No, okay, it's fine. As long as you hear me better. Is it better? Thank you. Thank you, I know. So the whole purpose of my research was restating the role of the dispute settlement body in modernizing, in adding, and what's more interesting, into creating new rules that would actually build for an analogous world. Hopefully I pronounced that correctly. So to get a better grasp of my research, firstly I'm going to define the topics that I'm going to use. I will briefly overview the current regulation of e-commerce under WTO law. Accordingly, the scientific problem that I wanted to tackle and address follows. And secondly, I will describe briefly the peculiarities of the WTO legal system and the dispute settlement body, as it will create preconditions for my further research on the what I would refer to as being the empirical research of the most recent case law of the World Trade Organization. And generally, the conclusions will finish up my presentation. So WTO is going to be used as the World Trade Organization, and for me, what's the most fascinating part about this organization, that generally it was, let's say, a complex of agreements, multilateral agreements between the majority of the countries of the world. However, through time, just like the European Union, it actually got more integrated, and it developed into a separate legal system. So the core agreements that are the general agreements on tariffs of services, on trade of goods, the dispute settlement understanding, they all form the core. It's kind of brave to say the constitution of some sort of the organization. And what's more fascinating, that as it is a legal system, it has its own judiciary body, which is the third part, the WTO DSB, or the dispute settlement body. It actually consists of the appellate panel and of the panels, but generally they may be referred to as court-like organizations. I'm going to briefly refer to them as being courts, as this is what they are. And the peculiar part here that is of crucial importance to the research is that genuinely the court has only a function of interpreting WTO law, meaning that it cannot add anything else. Generally, it cannot engage in judicial activism. However, the goal of this research is to rethink that function. So overviewing the current regulation of electronic commerce under WTO law is quite simple. There's one word, it's non-existent, because the core agreements were negotiated at times where e-commerce was completely irrelevant, meaning that in these agreements, electronic commerce is not incorporated and it's not considered. Therefore, the role of the court of interpreting something that is not there, it's inconvenient to say the least. When member states realize that there's some sort of importance due to the growing digital trade amounts, right? So in 1998, they scheduled a work program. That's sort of like a plan for the organization on what they should do next. So they reached they undertook the obligation to reach a multilateral agreement of regulating e-commerce. And accordingly, they issued guidelines on the application of current WTO law. However, it was of recommendatory nature, meaning no specific obligations were formed. Therefore, in 2018, what we have now is only one obligation for the member state. That is obligation not to impose custom duties on electronic transmissions. And as you may understand by now, is that each word of that obligation is quite narrow and broad in the same sense. Therefore, we need some kind of arbiter to interpret the scope of this obligation. Accordingly, the scientific problem is multi-layered in my perspective. So to begin with, WTO law is created for an analog world that does not encompass e-commerce. However, there's no multilateral agreement, there's no unified regulation of e-commerce in the let's say, in the international fora. So there's no harmonized regulation. However, the area is not left for self-regulation, which is generally the case when we don't have any multilateral agreements. Because as e-commerce and digital trades amounts are rising and growing, let's say, states engage in separate agreements between each other. Therefore, it leads to separate agreements that have different definitions, different application standards, leading to the application of different standards globally, let's say, which also, in my opinion, leads to different standards, let's say, of consumer protection. And just from a political perspective, just recently in 2017, I think, at the 11th Ministerial Conference that was held at November, that is actually one of the key decision-making bodies, like a conference on engaging in contracts, no decision was reached. No obligation, no nothing, just the member states only reinstated their wish to regulate and to do something about it. So in 2018, we don't have any regulation under international trade agreements, and that directly leads to the possible obscurance of free trade, which is actually the complete and utter opposite of what the WTO stands for. Because as I mentioned before, it was initially created as a mechanism, a set of agreements to liberalize trade. And given that in the near future, chances of regulating the sphere are, let's say, non-existent and not likely, I would suggest looking back, revisiting the current regulation and giving more powers to the WTO dispute settlement body. And this basically is preconditioned, this assumption is preconditioned by the peculiarities of the whole WTO legal system and the dispute settlement body as it is. So as it mentioned before, it is crucially important that WTO law is a separate legal system with its own rules and its own, I would say, judiciary organ. And inherently, WTO agreements are incomplete, meaning that it's for the courts, certain notions must be interpreted, and it means that the courts or the dispute settlement body must insert certain, I would say, content to the notions. Therefore, I come to the conclusion that judicial decision-making is utterly inherent to the system itself. Therefore, there's no reason to defy why the DSB shouldn't engage in the judicial decision-making. And I would suggest maybe providing more safeguards to limit the judicial activism rather than completely blocking it. Because this stance of the dispute settlement body is utterly criticized because it generally overlaps with the common decision-making procedure that is basically enshrined within the member states. What was a very fascinating finding for me during this research is that finding out the binary nature of WTO courts or the dispute settlement body, because as the panel or the appellate body enacts a report, we can call it a decision in that certain case, it does not only have to solve the dispute between concrete parties, it must also, that decision itself, it must also benefit the whole system. So I haven't seen anything like this. If you have any, how to say, insights from your own national systems or your own experience, I would love hearing your views, because for me this is actually quite a phenomenon of the World Trade Organization itself. So by one decision, we have to not also only solve a dispute between 2 or 3 parties, but the decision itself must benefit the whole legal system. And I believe that this creates preconditions for, particularly in the case of e-commerce, for the dispute settlement body to be given more discretion to decide in these cases. Because as I mentioned before, WTO law does not, how to say, technically, formally, does not encompass electronic commerce. However, the phenomenon is happening and cases are being brought before the dispute settlement body. So we must just do something about it. And an important part of the research is the empirical analysis of the 3 cases that they were already brought before the dispute settlement body. So as I mentioned before, the dispute settlement body, it generally has an obligation to interpret law, not to exceed its discretion. However, in these three cases, what was actually very fascinating is that the dispute settlement body, and sparing you the details of the particular articles that were negotiated in those disputes, the dispute settlement body, it exceeded its interpretative function, well, not literally saying that we're exceeding this and acting ultra vires, but they reinterpreted the law in such a way that it created new content, new rights and obligations for the parties. In the China audiovisual services, the court must have understood that it's overstepping its limits, therefore it took a little safer stance and backed off. Therefore, it explicitly did not address the problem of reinterpreting or modernizing WTO law in the case. However, it expanded the definitions in the General Agreement of Trade and Services in such a way that it also had a broader context than what the parties agreed upon when negotiating that particular agreement. And another more theoretical kind of importance of that case is that the court declared that all of the notions, systematically understanding it, that all of the notions under the General Agreement of Trade and Services are alterable. They must be evolutionary, as the system itself must embrace new technologies. So once again, rethinking the thing that e-commerce was never included originally in the agreements, the court adds new content to the agreements themselves. Lastly, in the China electronic payments, the court kind of took a neutral stance in this thing. They also reinterpreted the definition by expanding once again, the classification of certain electronic payment services. And so how to briefly present the case? They basically, one of the party was saying that, no, we agreed only to this classification that consists of the X, Y, Z elements. The court said, no. The definition in that classification is so broad that we have to encompass all the actual things that these services represent right now, not in the years when they were negotiated before. So briefly, turning back through all of my presentation, what we have a problem currently is that the WTO law must reinstate its position as the core of regulating international trade and maintain its relevance. However, there's in e-commerce, in electronic commerce cases, there's no harmonized regulation. That could be no problem if it would be left for self-regulation. However, it is not, because there's a huge diversity of separate agreements regulating the issue. And I would suggest for the short term to rely on the dispute settlement body by broadening its discretion, allowing it to broaden its own discretion, however, also applying some sort of safeguards just to limit its judicial decision-making so it wouldn't overlap with the member states' decision-making processes. Because the DSB, it has the capacity, and I even would go further saying that it has both the willingness to engage in not only modernizing and creating WTO law in e-commerce cases, and basically exceeding its own functions despite what the parties are saying. And this concludes my presentation. I would gladly answer your questions, or should we wait for the end? Thank you.
So thank you, Carolina. The next presentation, we have 15 minutes, so we are in time, of course, after Carolina's presentation. So now we have second presentation, and it's Julian Choi from University of Cologne. Now we move to another type of question, to antitrust law. So let our colleague to introduce himself briefly and start presentation. Thank you.
Thank you. It's a pleasure to be here. My name is Julian Choi from the University of Cologne in Germany. And the topic I'm going to talk to you about is about digitalization in antitrust law and about the methods and practices of digital forensics in the practice of the European Commission and especially of the German Federal Cartel Authority. So what I'm going to do, does this work? Yes, it works. So what I'm going to do in the next 15 minutes is, since we are from a great variety of backgrounds, I will just briefly talk about antitrust law in general, and then quickly turn into the importance of data forensics in cartel investigations. And if I have the time, I would like to address the importance of data analysis from a lawyer's perspective. So antitrust law in general, in a nutshell, is about promoting free competition, is about guaranteeing that all market participants have the same chances. And this aim is achieved through 3 regulatory approaches. First, merger control, in order to avoid a too high market concentration, to avoid market dominant positions. Sometimes we know that there are players on the markets which have a market dominant position. Antitrust law makes sure that they don't abuse their market dominant position. So this is the second regulatory approach. And the third one is the ban of cartels, which means prohibiting agreements among market participants which undermine competition. We know price fixing agreements, agreements to trade and production conditions, or the distribution of market shares. So my topic will focus on the ban of cartels, and in this context the importance of IT forensics. So why does it matter? First, IT forensic, what do I mean by that? Usually it's referred to the practice of extracting electronic data from IT systems and analyze it in a legally admissible manner. So this is one of the definitions I found. But it becomes much more, more obvious when you think of a cartel agreement as a conspiracy of some market participants against the market. And an agreement is, per definition, something which is committed by communication. So they have to communicate to initially reach the agreement. Then they have to put the agreement into practice, which includes internal communication and coordination. And then usually cartel agreements are a long-term story. The cartel members have to communicate again to adapt the agreement to new market conditions. So in today's business environment, communication is mostly digital. And for an investigator, this means that evidence is digital too. So this is why today in modern cartel investigations, data such as emails or electronic text documents are by far the most important pieces of evidence. So what I want to do now is to focus on the process of obtaining digital evidence. And this process can be divided in 3 phases, let's say. First, the investigator needs to access the data. Then it needs to review the data and to seize the data finally to use it in court. And I will go into detail of each of these phases by using the practice of the German Federal Cartel Authority, the FCA, as an example. So the first phase is by far the most exciting one, is the famous dawn raids, when in the morning the cartel authority knocks on the door of the premises of the alleged cartel member and raids the building. They put everything upside down. They have the same, I don't know if it's in each country the same, but in Germany the criminal procedure applies. So they have the same authorities as the public prosecutor, which also means they need to get a search warrant from a judge. But how does it work? The IT unit, they are always coming with a group of experts. They get in touch with the IT system administrator and demand access to the servers. But since we're in criminal law, there is the principle of, or the privilege against self-incrimination, which also applies in cartel investigations. So employees are not obliged to actively participate, but only to tolerate the investigation. But interestingly, the principle of self-incrimination does not apply to people who are in have no connection with the cartel charges at all. So for example, an IT expert, where it's sure there's no risk of self-incrimination, so he may be questioned as a witness, and then he has to explain by law, he's forced to do that, how to access the server, or he can even be forced to give passwords. But in practice, interestingly, this doesn't play a much important role, since corporations tend to cooperate and give access to their servers voluntarily. Why do they do that? It's actually quite reasonable, because they know that the authority can break into the server rooms and just take the hardware away if they want to. So since the company has an interest that the raid goes as quickly and smoothly as possible, they give access voluntarily. But an interesting point in this context is how to access, or if the authority can access data stored on external servers. And here I'm referring to the famous cloud computing, so a network of external servers where the data is stored. And the German criminal code for a criminal procedure has a special provision on that, which says that the investigator can actually access the cloud subject to two conditions. First, the company named in the search warrant needs to have online access. And second, there needs to be a danger of losing the data. And since per definition, data stored in a cloud, the access is controlled by a third party, there's always the risk that the authority may not get access anymore. So in practice means that they also access data on external servers. But what about servers located abroad? This brings up questions of international law, because when we think that the authority of one state is interfering with data located on the territory of another state, this might be an interference of sovereign rights. But nevertheless, and this has been granted by German courts as well, the access doctrine I just explained is applied. And why is that? Mainly for two reasons. The first one is the efficiency of the proceedings, because it would extremely undermine the efficiency if the authority could only access data located within Germany. And the second one is a more technical aspect, that data stored in a cloud environment can actually not be located, because even the cloud operator is not able to tell whether a specific file is stored at a specific server, because it's permanently transferred within the network of servers and processed, so sometimes files are split up. So if you can't locate it, you can't say, we're sure that the file is abroad, so we can access it, so we do that. So this is quite a pragmatic approach. The German and I think the European Commission does that as well. So now the investigators have access to the data. The second phase is they have to consider which data is actually relevant for them. So first what they do is they seize the data which might be potentially relevant. And the picture here is actually quite a bad example, because it doesn't reflect the current practice. The authority does not take the hardware away, but instead they copy the data. So they bring their own storage devices, and they do this for, again, two reasons. A practical one, it's more convenient. And the second one is, from a legal perspective, more interesting. Taking the hardware away is, of course, much more painful for the company. And since the authority needs to act in a proportional manner, copying the data is a least restrictive measure, and so it's more proportional and is more a due process than taking the hardware away. But this brings us to another problem, since copying is always a risk for the evidentiary value of the file. Because lawyers afterwards could argue, but this was not the original file which was on our server. Now you modified it. So how do we ensure the integrity of the data to keep its evidentiary value? They use the so-called hash procedure, which I have to say I only understand from a very basic point of view, not the technical details, but an IT expert told me about it, and this is what I understood. So if you have a file, the software within the copying process registers thousands of different data properties, and an algorithm transforms this into an individual checksum, the so-called hash total. And this hash total is individual to each file, and even the slightest modification of the file would lead to a different hash total. So in the end, when you see that the hash total is the same, you can be sure that the chain of custody was intact from the copying till the moment where the file is evaluated by the court in the proceedings, which can be years later. So this is quite an efficient way to guarantee the evidentiary value of copied files. And then we come to phase 2B, the actual review, and this is where the real work starts. So the investigators come back in their premises, in their offices, with the stored devices, and now they have to review the material. How they do that is within their margin of appreciation, but they still are urged to do this as quickly and efficiently as possible. Again, practical reasons, they only have limited resources. Legal reasons, because due process requires them that the length of the review is not disproportionate to the amount of data. And more importantly, in cartel investigations, you have a limitation period of 5 years. So they need to complete the whole proceedings within 5 years, which may sound very long. But if you have complex cartel investigations involve several companies and terabytes of data you have to analyze, you have to build your cases, 5 years is actually not that long. So the review is all about efficiency. How does it work? And since what is costly are the lawyers, so the aim is to reduce the amount of data which actual human lawyers have to go through as much as possible. And this is done in basically five steps. So we have, do I have a pointer here? Yes. So we have the total amount of data from a certain company. And the first thing which is done is basically common sense, is a rough selection, very rough selection. You concentrate, for example, on the relevant business unit. If you are investigating a steel cartel, you leave the business unit dealing with copper, you just leave the data where it is. Then within the relevant business unit, you make a selection and you filter out system files which are generally unfit to have evidentiary value, like system files or something like that. Or you filter out identical files. Sometimes you have the same contract 300-400 times with a slightly different name on different client computers. The third step is prioritization of data. Here it gets more sophisticated. The data is not filtered out, but you create different categories or subsets of data, and then you analyze them one after another, starting with the most relevant one. So for example, I have here this is my whole stock of data, and now I only want to analyze emails from Mr. A to Mr. B between March and September, because I think the investigator thinks here is a high probability that I will find something interesting. So then you have this subset of data. Next step, you run a keyword analysis over that data with a special analysis software. And if you are lucky enough, the keyword results will be only a few hundred files. And then this is where the manual review is starting. So this is where the lawyers of the cartel office are spending months of going through each file and tagging the file. So they go through a file and then they tag relevant, not relevant, or maybe relevant. And the challenge of digitalization is that this stock is getting larger and larger every year, but the budget for manual review isn't keeping up with the amount of data. So we need to get this manual review smaller while this is getting bigger and bigger. And one possible solution is, which in almost every field, probably artificial intelligence. There are new software products which use predictive coding. So what is done here, the manual reviewers, the lawyers start to review files, and after a few hundred files, the software takes the decisions made by the humans and develops on this basis its own search strategies and transfers them to the other data which haven't been reviewed by humans. And there's a recent case study, but it is published by a tech firm, so I'm not sure how reliable it is, but they claim that their predictive software is able to reduce the manually reviewed software by 70%, which is quite impressive. So if data analysis has such a strong impact on the investigator side, I will now very briefly talk about the impact on law firms. So I ran a survey, I conducted a survey, and I asked 29 law firms. I actually asked much more, but 29 bothered to answer. How important is data analysis in your practice? And you see, so they basically come from all kinds of backgrounds, from big international firms to boutique firms, but they all are specialized in IT, in antitrust law. And the result was quite interesting, actually. When I asked them what kind of measures do you want to apply in the future to keep up with the challenge, almost 60% said, well, we're gonna invest in software analysis and we're gonna hire data analysts and IT experts. But roughly 40% said, well, we're gonna hire more lawyers, use external project lawyers, or non-legal staff for doing the review. So this shows that digitalization has a huge impact on how law firms work and how law firms build their capacities in the future. But it also shows that we won't be replaced by an algorithm anytime soon. And with this good news for all the lawyers in the room, I thank you for your attention.
Thank you for giving promises. That's good to hear. So now we have third and fourth presentations for tax law. And the first will be given by Alessandro Lotta from Luis Guido Cavalli University. So a few words about you, and please. Thank you.
Hi, everyone. I'm Alessandro Lotta. I come from Italy. And I'm really happy to be here because 6 years ago I did my Erasmus project here. So I'm really happy to be back. And I'm sorry I didn't bring any slides, any presentation, because I actually had them, but I left them in the room. So I'm sorry for that. And so in case you wanted them, I may send them by email. But anyway, the topic I'm going to talk about is about tax law, of course, and the relationship between digital economy and tax law. And so I'm going to start by mentioning what are the steps that led to certain proposals, certain directive proposals. And the starting point is the current inadequacy of the international tax system. And it's inadequate because, according to the OECD, it was created for a brick-and-mortar economy, which means an economy which is based on solid activities, right? So not on digital economy, of course. And so in 2015, the OECD released and published the final reports of a project, which is called the BEPS project. And BEPS is an acronym that stands for Base Erosion and Profit Shifting. And basically, those actions would like to tackle all those problems that derive from aggressive tax planning. And so basically, tax avoidance, tax evasion. And so there are 15 different action plans. And most of them are related to digital economy. But maybe you don't know what base erosion and profit shifting means. Okay, so actually what it means is that a multinational enterprise builds a structure, a multinational structure, so that it can shift profit. So I put it very simply. It can shift profits from high tax jurisdictions to low tax jurisdictions so that these profits are taxed at a very low rate or no rate, and so it can keep a certain advantage in the market this way. So the OECD looked at this problem from a tax point of view, of course, and wanted to find a balance between the allocation of taxing rights on the one hand and the possibility of certain multinational enterprises to carry on their activities. And as I said, most of these actions are related to digital economy. All of them are related to tax avoidance. For example, there's Action 3 that regards controlled foreign companies, and there's Action 6 that regards abuse of treaty. But above all, Action 1 is entitled Addressing the Tax Challenges of the Digital Economy. And what it says, in a nutshell, is that our system is not adequate, and digital economy and those business models that are based on digital economy and intangibles can be a potential and are an actual danger to the tax administration, because using or misusing digital economy and those business models based on it may lead, and most of the time lead, to profit shifting, as I said. So the OECD came up with some solutions, and the OECD was and is aware of the fact that it's impossible to solve the problem easily and in a brief period. So there are two different options that the countries may choose, which is adopting short-term measures which are not the best, so they're not really recommended by the OECD because they're considered not as effective as the long-term measures, in the sense that they can solve the consequences deriving from the misuse of digital economy, but they cannot solve the actual problem. And the long-term measures, which are supposed to be effective in the long term, but of course it takes some time. So if this is the starting point, then my presentation is about what the EU is doing or would like to do. And 2017 was a very important year in this respect, because the Commission has sent letters to the other institutions, and in early December 2017, it sent a letter to the Council, and it showed the need and the urge to intervene in the area of digital economy by creating a digital single market, which I think is really important, because the Commission is aware of the fact that it's necessary to build a digital single market alongside with the internal market, which, according to some statistics, is worth like 415 billion euros per year, so it's quite a lot. And so in March 2018, two different directive proposals were issued, one of which regards a short-term measure, and the other one regards the long-term measure. And they're quite different from the ones that were expected, because in 2017, December 2017, three different solutions were proposed by the Commission in the beginning, but now what the Commission has come up with is very different. And just a couple of remarks about the other initiatives that come from the EU. These proposals I'm going to talk about are not the only tools that the Commission has issued or would like to introduce in the European legislative framework, because VAT directive on e-commerce has already been approved, and the Parliament is supposed to discuss about a new directive which regards the CCCTB, which I assume you don't know what it is. It's the Common Consolidated Corporate Tax Base, and it's basically a way to determine what the tax base of corporates is, so that it can be taxed in a homogeneous way by all the countries. For what concerns the short-term solution, the Commission has proposed a directive to introduce a digital services tax, which is a 3% rate tax that has certain characteristics. I'm going to describe them very briefly. And what I would like to point out before is that the Commission adopts a competition-oriented approach, which means that the Commission doesn't see taxes as, or at least doesn't see the right of the countries to tax as a value itself most of the time, but it sees as a vehicle to reach the objective, which is competition. So that's very interesting from my perspective, from my point of view, because in the past, especially if the Commission and the European Court of Justice had to deal with the fundamental freedoms, the allocation of taxing rights and the right of the states to tax certain profits was not considered a value at all, because of course the European values had to, didn't have to be breached, so they couldn't be violated by national legislations. So it's very interesting for me that now the Commission adopts this approach, which would like to protect, in a way, the taxing rights of the countries. So the digital service tax is a tax that is going to be applied, or is to be applied if the directive is approved, on the revenues that derive from certain digital services. And these digital services have to produce revenue, of course, because otherwise no tax will be applied. And they basically are belong to the following categories. So one of these activities is providing advertising facilities. So advertising through a digital interface, which means that what is going to be taxed is the revenue that derives from the advertising on that digital interface, basically. The second type of transaction that is taken into consideration by the proposal, so by Article 3 of this proposal, is the transactions that are carried out through multi-site interfaces, so that to put it simply, these interfaces are created so that consumers can meet each other and can provide and sell and supply goods and services through it. So the revenues that derive from that. And the third type of transaction involves the exchange of data. So the revenues that derive from that. The point of the DST is not to tax every type of transaction, as I said, but so from a dimensional point of view, it wants to tackle those aggressive tax planning that regards big amounts of money, of course. So two different thresholds have been introduced, one of which regard the total amount of revenues that derive from the activity of the taxable entity in the tax period, which is 750 million euros, which is quite a lot. So it means that only the biggest entities are going to be taxed according to the DST. And the second threshold regards the total amount of revenues that the taxable entity gains in the EU, so in the territory of the EU, in a tax period, which is 50 million euros. So again, it's quite a lot. And so what needs to be taken into consideration is the dimension of the company, of the entity that is taxed, and the amount of revenue that derives from its activities. And of course, it's not important if the interface, the digital platform, belongs to the company that delivers the service, the digital service. What matters is that the company can use it. So this is this is the key point. And for what concerns the place of taxation, of course, as there are different types of transactions involved, or that could be involved, the place of taxation changes. And this is extraordinary from a tax point of view, because most of the time revenues are taxed on the basis of residence or source country. And in this case, what is going to be taxed is the place where the tax is going to be applied is, for example, the place where the device on which a transaction is carried out is at the moment of the transaction. So if the device is in Italy, Italy is going to have the right to tax according to the directive. If it's Lithuania, it's going to be Lithuania. So that's really peculiar of this type of tax. And so before talking about the DST, I mentioned some EU aspects that I found interesting, such as, for example, the fact that Commission has this competition-oriented point of view. And another thing is that some commentators believe that the DST could make some problems according to Article 107 of the Treaty for the Functioning of the EU, which regards state aid, because one of the key points of state aid of Article 107 is selectivity. So what has to be, what people have to focus on and what countries have to focus on when introducing the DST is if this tax is going to be considered as materially selective, that is to say, if it taxes as, and so if it doesn't, or better yet, if it favors those transactions that have basically the same content that otherwise are not carried out through digital platforms. It's really complicated now to state if this is going to happen or not, but you know, this is the problem of dealing with taxes and from the legislator point of view. And another important thing I wanted to mention is that generally speaking, the EU doesn't have competence for what concerns tax law, because back in the days when the EU, which wasn't EU, so the European Community was created, they didn't think that tax could be such an important part of legislation and didn't think it could have so much influence in the internal market. But what's going on now is that the Commission has started little by little to push very hard on the topic of tax, and it turned out that most of the pieces of legislation that have been discussed and that are now going to be approved regard tax law. And for example, in 2016, some of the suggestions that came from the BEPS project were adopted by the EU in a directive, which is the Anti-Tax Avoidance Directive, that represents a very important step towards the harmonization of the tax system. The last thing I would like to talk about is the concept of virtual permanent establishment, which is the long-term measure. Just a couple of things. I'm not going to talk about, of course, the amendments to the concept of permanent establishment, but what the EU wants to do is to add another content to the original one, which is the virtual permanent establishment, which is based on the concept of significant digital presence. That is to say, if certain conditions are met, so for example, if the proportion of total revenues obtained in a tax period are resulting from the supply of digital services is over a certain amount, which I believe it's 7 million euros, and other conditions are met, then in that case, there is going to be a significant digital presence, even though there is not a physical presence. And the state where the significant digital presence is has the right to tax. So I'm done, I think. Yeah, I'm done.
Thank you, Alessandro. And so we will continue with taxation matters and Arthur Tim from University of Lutz. So a few words about yourself, if possible, and what is
Good afternoon. My name is Artur Tim. I'm a PhD candidate at the University of Łódź in Poland. I'm also a Polish tax advisor. I would like to thank, first of all, I would like to say that I'm honored to be here and to have the most difficult part of every conference. That's the last speech before our break. I know that everyone would like to go sightseeing, so I promise not to exceed over my 15 minutes of time. I will be talking about taxation of the digital business models in the national tax law. Of course, I will try not to repeat what Alessandro has said before. I think that our presentations will be complementary. So, to begin, I will be talking about digital business models. I will give some general remarks concerning that issue. Then I will present the essence of international tax law and taxation of the digital business models. That issue will include also an example of functioning such an outdated system. Then I will present shortly mostly OECD approach to that issue, and I will skip the EU, the EU approach, and then I will make some conclusions. So, what are the most important features of the digital economy for the tax law? First of all, it's a phenomenon which is called big data. Only selected kinds of digital activities generate 2.5 exabytes of data every day. 1 exabyte is 1 billion gigabytes. Oh, you can see it here. That is circa 1.5 billion of cities. It's a huge amount which is created and which is being sold just as every other good. Another issue is its volatility. Digital economy is very volatile, more than the traditional economy. We couldn't be sure if we are living still in that same century. For example, the new iPhone, I'm not quite sure what's the number of the new iPhone, 5 or 6, 10, yes? Okay, so that's the example of how our world is changing now. Another issue is its mobility. We can manage our enterprise from every place in the world. For example, now when I'm in Vilnius, I can establish a company in Poland only via internet, or even in Cyprus. It's something completely different than in the conventional economy. And one of the last features is, what if I told you that you are living in the matrix? It's a phenomenon called establishing some kind of network between users. For example, what if I was the only person which created the Facebook account? So what is the point of being the only one who has a Facebook account? It's pointless. So our actions have to be connected with reactions of other internet users to have a point in that reality. And the last feature, its tendency towards monopoly. Have you ever tried to use Linux? It's yes, I have tried, and it's something terrible because any kind of program is compatible with such a system. So we all use either Microsoft or Apple or products of Apple, and there's the third competitioner in that field. On the other hand, what are the features of the conventional economy? Conventional economy is something like that. Like that knight and his servant in the modern world. It's something completely different that these features concerning digital economy. It's stable, it's strongly connected with the physical presence, something which is irrelevant in the digital world. And now I will talk about examples of taxation of the digital business models, which are relevant for the Polish for the issue. So to begin, what is the basic rule of the conventional economy? Let's create a company in one certain jurisdiction. That's a company. And that's the second jurisdiction. That's the first jurisdiction. That's the second one. That company receives an income from the territory of the second jurisdiction. General rule is taxation only in the resident states. That means that every income which will be created in the source state will be taxed only in the resident states, with one huge exception. That exception is related to the concept of permanent establishment. Permanent establishment is strongly related to the physical presence. If the physical presence is strong, then the source state can also participate in that income by imposing taxes on it. For example, permanent establishment is created by a mine, by a factory, by construction sites, or by a work office. The most important requirement is a physical presence. And then it is possible to impose taxes in the source state. For example, we've got two jurisdictions, Ireland and Germany. In Germany, CIT rate can be even 36,83% for the reason of your Gewerbesteuer. Yes, that's the most important thing that we have to also remember when we are dealing with German companies, that you also have some kind of tax which is hidden on the level of communes. And what do you think? There was a very important case concerning Apple. What was the effective tax rate imposed on the income of Apple? Any ideas? 5%, 3%? Yes? 1%. Less than. Yes, that's true. It was something about 0.005% of generated income. But in the conventional economy, as we can see, Germany can impose taxes in that rate which is indicated in slide for the reason of creating the permanent establishment within its territory. In Ireland, taxpayer can only deduct the tax paid in Germany, so effective tax rate is exactly the same as it is in Germany. And what if I told you that physical presence is irrelevant? We are living in the digital world. And if so, we have that same situation. We've got a company in one jurisdiction and income from the another jurisdiction. General rules are exactly the same, but in that case, we have no physical presence. For example, Apple Store or portal like Airbnb or Booking.com. We pay for some kind of services via internet, and there's a lack of physical presence. Servers are located either in the first jurisdiction or in the other jurisdiction. In that case, of course, source state try to apply their tax provisions, but on the ground of the international tax law, it is it is not applicable. Therefore, in our Apple case, we've got an effective tax rate just as in Ireland. That means 0.005%. So that's the example how digital economy works and how it is treated on the ground of the tax law. Reaction of our reaction is just like this. We are not able to react on that phenomenon in an effective way. We are just watching on that phenomenon. What are the basic rules of international tax law? And what's the reason of such a state? That rules were created in the 19th century where the conventional economy was the only way to conduct business activities. Double tax conventions are the most important bilateral mean of avoidance of double taxations, and they are completely outdated in that field. All of the double tax conventions are based on the UN or OECD model. That is the reason why the OECD approach is so important. Application of that rules results in a lack of effective taxation of digital business models. As we can see in the European Union, the effective tax rate in the case of traditional business models, traditional international business models, is about 23%, and in the case of digital ones, it's 9.5%. I will now shortly present the OECD approach on that issue. So we have two possible solutions of the issue of the digital economy. Do you want to take the OECD pill, or do you want to take the EU pill? We will take the OECD pill because the EU pill was presented in a comprehensive way before. So, OECD in 2015 issued the report called Addressing the Challenges of the Digital Economy. The word addressing is very important because in the international tax law, it is stressed, in the international tax legal doctrine, it is stressed that OECD only addressed the challenges but not met the challenges of the digital economy. A recommendation of the OECD can be concluded in that way: keep calm and do your best. Our reaction, both at the university and as professionals, was something like that. So that is your final recommendation. Of course, it is not sufficient to tax digital business models in an effective way. Therefore, some EU countries in August 2017 required a strong reaction of the European Union, especially the European Commission. It was Spain, it was Germany, it was Austria, and I think it's all. Then the other European jurisdictions also required such a reaction. Therefore, 2 months ago, European Commission issued a communique, and the conclusion from the communique is something like that: we will tax the digital business models in an effective way, just as we could. In the United States, they did it, but they did it not with the use of force of law, but with the use of law of force, because they negotiated with Apple, for example, to bring their business to the United States. The negotiations were secret. We do not know the details of that negotiations. However, they did it. That was our reaction that was how we were waiting for the European Commission decision, European Commission project. But the general conclusion may be illustrated in that way. It's something, there are 2 basic means of reaction which were coined by the European Commission. The first one is a new directive concerning significant digital presence, and as it was told, digital permanent establishment. That's a long-term solution. And the second one is the interim solution, indirect tax for the most important digital entrepreneurs, which also has been presented. General conclusions may be like that. Taxation of the digital business models is one of the most important issues, being as high on the international political agenda as, for example, climate change. It's very important, especially for the budgets of states in the whole world. Fundamental rules of the international tax law were created in a completely different economic reality in the late 19th century. And the general question is, are there any alternative models of international taxation? Because one of the ideas how to deal with the digital economy in the common world is, why don't we repeal the income tax? And that's a very serious idea, because our income tax, it is called Schanz-Hayek-Simons conception, has been created in the late 19th century. It has not been since always. It's a quite new institution in our history. So maybe that's the time to replace our income taxes by some kind of other income taxes. For example, income taxes based on consumption, or replace direct taxes by indirect taxes. That's the open issue in the international tax law doctrine, and I think that we should be aware that in the nearest future we will be asking why don't we repeal the income tax at all. Thank you for your attention, and if you have any questions, so of course we can ask. Thank you.
Thank you very much for so different presentations, and I think that relying on this diversity, we might ask some general questions, you know, just uniting all presentations. And as a moderator of this panel, I will use this position to ask first question. So my question would be as follows. We heard, you know, there are two positions actually. One position to do nothing, and what we heard from Carolina's presentation and about the OECD in tax law, simply rely on what we have and interpret the law in the broader way. It could be explained by various reasons. One of them, for example, that law is always runs back after the changes in the business. So it could be. So why should we work in long term some huge amount of papers if once it's already valid, it's obsolete, yeah? So it could be told like this. Another position is that, of course, we need regulation because, you know, there are a lot of questions like taxation, we lose money, even if it's not tax evasion, it could be tax avoidance, but still. So legal certainty, predictability, etc. But what do you really think? Which way we should go? It's for all of you.
Yeah, that's a very good question, a general question. I think when we think of an answer, we should think of the function of law in general. It needs to not only regulate, but also reflect reality. And to do so, we have methods of interpreting the law and applying the law. And interpretation, we have a margin of interpretation. But once reality has changed so much that law isn't reflecting reality anymore, and we can't stretch the law, then I think we need to change the legal framework. And I'm definitely have only very basic ideas of international taxation models, but I think that here a new framework is required.
Other ideas?
Well, I totally agree, actually. And when I was at university, I took a class of philosophy of law, and I studied a book by Anna Arendt. I don't remember the title, actually, but what the main concept was that law cannot innovate, because what law actually does is to, as you said, reflect and consolidate what the changes of reality are. So from a tax law point of view, tax always comes later. So if there are developments in reality and developments in the creation of income and for example, as it happens in digital economy, then intervening is the only option, because every time there is a way to avoid taxes, then be sure that someone will use them. So also because there are some people who are paid to do that. So I think that it's necessary to have an aggressive approach towards digital economy, because it seems so unreal, but it really affects our lives. So an intervention by countries or international communities or the EU is definitely required. And I think it's the only option. There's no way to stay in front of the issue and hoping it solves by itself. It will not, in my opinion. And that's just my opinion. I think you'll agree.
Thank you for this very important question and for your statements in that debate. I totally agree with you that changes are required, and that's also true that the tax is always later after some phenomenon occurred. But we have to also remember, we have to also be aware of that we cannot implement new solutions too late, because that what we can see now is a disaster for the international tax law. Our rules are completely outdated. OECD, for example, proposed to sign an instrument called MLI. It's a multilateral instrument which will change all of the double tax agreements across the world. But as I know, it is not a very important for the issue of the digital permanent establishment, because the changes are not as far-reaching as they were expected to be. So if you asked me 5 years ago if it is possible to replace our income tax by some kind of other instrument, I would be laughing. But now, very important persons in the international tax law, they all agree that we have to change our system. For example, in Munich, Professor Wolfgang Schön does his research concerning alternative models of the international tax law. That's a very important issue, being very high on the not only political but also on the academical agenda. What is the best way to tax both conventional and digital economy, having regard that the digital economy is our future? So I totally agree that we need to implement new solutions. The only question is how far-reaching should these solutions be? Should we only replace some loopholes by some certain solutions, or should we repeal income tax in the shape as we know it from our experience and introduce something more? In my opinion, of course, that's only my opinion, we should implement some new regulations because the old ones are completely outdated. And we have an example of United States of America, which budgets are completely based on the direct taxes. But for example, in Poland, direct taxes are not effective, and our budget is grounded on the indirect taxes, for example, VAT and excise tax. So we can implement some kind of indirect taxes on income received in our territory, and we should be aware also of that in the income taxes it is not as easy that in the field of indirect taxes, for example VAT, it is not so easy to avoid taxes as, for example, in the income taxes. Thank you.
discussion at a completely theoretical level, I'm listening to this and I believe that we're putting too much emphasis on the law and assumptions. We're making it an ideal because somehow we must all agree that it will always drag behind us because it's impossible to foresee the future. Therefore, just to add to this discussion, I would suggest firstly that taxation is a completely such a niche sphere that I believe that we have to have like different competencies in that sphere, not talking too broadly about it because it needs to give attention to it. But I would like to emphasize additionally that I do not believe that law operates in an empty space because we have a general principle, something that keeps working still. Because what we have here, tax law is out, tax law, and not infinitively. What you guys are speaking about, it's outdated, but somehow the world goes further. Somehow things manage to regulate themselves. So I would just like to emphasize not the importance and the idealistic role of the law, but let's say that the law should not interfere with the processes that are going along. This is my personal point of view on this. And another crucial point is not because we as lawyers, we have this urge to regulate stuff. I suggest also looking into the application of certain rules, maybe ensuring more flexible application, not necessarily very broad scope and comprehensive regulation of issues. This is what I would add. And excuse me, sir, I saw you like nodding and reacting very intensively. So I would like to throw the question to you. Do you agree with our points, or would you like to add someone? I would like everyone to engage.
About what?
You were looking very serious about the taxation law.
Because I like tax. I like direct tax, not indirect taxes, and I think that's very bad. This is a huge problem in Poland that we have built our budget mostly based on indirect taxes. I think it was a huge mistake, and it should be. We should go back to the past and do it properly and based on the direct taxes, because I think they are much more, from the social perspective, they are much more interesting, especially when you look at this Piketty work on capital and his proposal for the global tax, and the function of the direct taxes from the social point of view, a social coherence point of view, they are much more important and much more interesting. First thing. And the second thing, I'm not so keen on saying that, of course, the lawyers has this ability to over-regulate, and this is a bad thing, but I think that also I don't agree with your statement when you said that, for example, tax law is something which should be focused for the specialists or whatever you want. I think this is the crucial thing, and it should be broadly discussed. And,
I meant to say, if I may, that I have very narrow competence in discussing some kind of thing with your tax law.
Yeah, of course.
Okay.
No, but I think that, you know, like GDPR, it's also, you could say that it's also very specific. Data protection, data privacy, it's also very specific. And so tax law is also specific, just different kind of specific. So maybe that's one thing. And the other thing that, well, maybe this discussion is maybe more based on taxes and taxation, but this, for example, blockchain, and it's also blockchain, and we do not know if it's compliant, if it could be in compliance with the GDPR, and it's a huge question, and it's also part of the digital economy, and we also don't know what to do with it and what to think of it and what changes we should make, and it's like we are like from Tim's slides, we're in the matrix and we don't understand that we are in the matrix and we have no idea what to do. So that's maybe the big problem, in my opinion.
If I may add, actually, for example, in tax law, that's specifically, but in company law as well, there are a lot of processes going with digitalization, and the courts, they simply cannot, and they are not authorized to create the law, in many countries. So we do have a problem with the role of court as well, and a lot of practical problems. For example, transfer of company from one country to another. so many questions, of course tax related, but also so many legal questions. And ECD court has not created the rules because it's not role for the court to create the rules. So I think that also I would probably agree that we need a regulation, but what I also think that we need to do this much more quicker. And if we don't know something, we probably, I could agree, rely on some principles, but you know, we probably need something. This is my personal view. If somebody wants to add, it would be great.
Because you spoke about the role of courts, and I have a question for Carolina, actually. Because I found this very interesting. You said the current problem we have in the WTO system, one possible solution is to give more power to the dispute settlement to the tribunals of the dispute settlement mechanism. How would this work, or how would you? Do you have any idea how?
I actually wrote an article on it, so
Mm-hmm.
I have some idea.
Yeah.
If I may, how to say, elaborate on your question, what you're specifically asking is like, what kind of measures should we grant the DSB?
Mm-hmm.
What is actually happening already?
Yeah, I would be interested in both, and especially if you think that this is practically possible. When we think about the discussion of international courts and their legitimacy of arbitral tribunals, they are much criticized. So do you think that this could be put into practice? Would be interesting to
I
know.
would even go further and say that this is already happening.
Mm-hmm.
For your question, actually, I'm absolutely fascinated by the topic of courts and procedural rules. So what is the DSB doing? And it's very interesting for me is that in certain points, they're moving very slowly and delicately. The DSB broadens its own discretion. So there's a particular exemption in the rules where, in a certain, or say, certain conditions are met, the court may establish its own working procedural rules if certain conditions are met. But conceptually, that doesn't happen. The court seems to be necessary. For example, the inclusion of amicus curiae. So that basically the court has to interpret WTO law. But functionally, what empirically studying what is happening is that the DSB, let's say the WTO court, goes beyond WTO law and accepts any information that may be necessary. So that's why we should rely on it, because if when in times when it's necessary, the court may broaden its own discretion and add additional sources of information, leading further to more comprehensive analysis of the question. In that particular case, actually one of the problems of what the WTO has, it's a very common narrative that the organization is losing its relevance. However, I think it may reinstate its role by relying on the courts. I lost my thought. Excuse me. In that particular case of regulating digital trade, as I mentioned before, the court cannot, formally, it cannot invent anything, or it cannot add anything in its own discretion. However, what the court should do, should it reject cases of e-commerce, saying like, no, WTO law does not cover this, or it actually has to do something. So I would only suggest looking at the law as it is. What it is that the court is engaging in judicial decision making. That's it. If you have any problems with it, create safeguards, add any additional mechanisms, because this is what it is at the current moment. So adding, joining our two discussions, of course, the only long-term solution is to enact some sort of agreement. Maybe in the taxation area, things move faster. However, in international trade law, it has been moving for 20 years. It's 20 years and nothing has happened apart from political declaration that, yes, we should regulate. We are important, but actually they're doing nothing. So this is why I think we should apply a more pragmatic approach to things, and if undermining some sort of procedural technicality, saying that the court cannot invent some kind of new rule. The court is not crazy. I mean, come on. Its decision must benefit the whole system. The court should not invent something extraordinary. It should add to the legal development. So that's my general point of view to what the court does and should do, and what it actually is doing. Have I answered your question? Because I think I raised 5 more.
Okay, thank you very much. Any question from audience? Please.
first I got interested as how it's not functioning actually proving its relevance. However, when you go deep down inside, it's the only plethora for all the members of the majority of actually the countries are members of the WTO, right? So many disputes are being solved there, and I believe that it's important is many of the organizations are regional or they're very fragmented, meaning we have no common ground. And the WTO, as I see it, it has the most common ground among all member states. For example, what was happening with the Trump's medal tariffs here, you must have heard it. That was one of the most celebrated events when WTO law was mentioned in the media as being important, so we celebrated it. But what it actually does, maybe people do not talk about it enough, as should be done. Maybe that's my subjective point because I'm having my doctorate degree out of it. But the WTO law, I believe, is not only a legal regime that should be treated formally, it also applies some sort of political measures for the countries. Just for me, and a simple example would be that under any other regulation, EU would not have any, how to say, any form or grounds for reciprocal actions against the US. And what the US main goal, the goal of the United States was to attack China in some sort of way. However, EU was most significantly affected. And now the ongoing debate on what will happen with the EU, can it apply anything? And the WTO law offers many options. 3, I think, many. So the decision, if it goes to court, to the dispute settlement body, is going to be very fascinating because we have a very small technical problem there that I'm getting too elaborate on the topic. I really, it's very interesting for me. But what I mean is that WTO is underrated because it offers a lot of mechanisms. For example, right now, the European Union under the rules of WTO can, without hesitation, apply measures of reaction. So the law quickly took action to follow that for the political agenda. I
Thank
don't know whether I'm rationalizing the WTO law or it doesn't make sense. Maybe you know that the case was very far away. They really don't speak about it. We don't have courses at this university, so that's we're going to the educational system problems now. We only study European Union as such, as a given, as an ideal. We should look further and analyze the use of external relations as well. So being seeing the world further, seeing everything more integrated and how everything interacts on each other. Because the WTO directly affects EU, and EU and US are the most. I'm considering whether the US or EU has the most cases before the WTO. But actually, the World Trade Organization, another issue that I'm analyzing currently, is that the World Trade Organization directly says that the law of the European Union is not in compliance with WTO. And remembering the thing that EU law is so supreme and so has so much primacy, but there's another institution that says that the European Union regulations are in contrary with another global standard, and who has the authority to interpret EU law? Only the Court of Justice of the European Union. So I think that we're not talking about it enough.
Thank you very much. I think that, we probably missed already all our timetables. But anyway, I would like to ask from panel, do you have any question from the panel for your colleagues? No, okay. Any question? Okay.
I read a very funny article. Just started thinking about it. Sorry, it's completely ridiculous and unnecessary. But we were talking about the data that can be used as evidence in cases and everything. It's an off-topic, but I just recently read a very, I would say, serious legal analysis of how emojis can be used in courts. And for example, how a boyfriend sending to his girlfriend a picture of a gun and a dead smiley face actually was submitted as evidence in court.
When we think about a WhatsApp communication between two managers, and the one says, well, will your prices change next year? How about 5%? And the other gives a thumbs up, you have a cartel agreement. Here we go. So,
Sometimes it's the pinpoint details.
exactly.
Those cost a lot. Huge fines.
Okay. Last question from the audience. Okay, thank you.
Final remark, especially for the antitrust. I think that right now data mining to limit the scope of the data they have to produce. But right now, we still need a lot of lawyers to analyze it. And I think there's an evolution I've seen in M&A where people really believe that within and maybe the coming 5 years, a lot of lawyers will be replaced by artificial intelligence. We will actually, the computer will learn and it will actually analyze and without the same thing, if these 5 arguments are the only relevant ones, then we will not need to well, a lot of jobs maybe might become obsolete due to such evolution. I don't know what do you think about that?
Yeah, well, when I think about the survey I conducted among law firms, many of them, as I said, from small ones to big international ones, are considering to hire more lawyers, invest in both, in software and lawyers. And the survey is actually much longer. I only presented a very small piece, and I asked them, do they consider that software, predictive coding solutions, will be able to provide a full competition law analysis in the foreseeable future? Almost everybody said it's not going to happen. So maybe we are also a little bit too enthusiastic about what software is able to provide. On the other hand, lawyers always consider themselves to be irreplaceable, so I guess we'll have to wait.
I also could make a comment about this AI lawyer and well, lawyer legal person. There are some in the United States I've read, and I believe that to be a trustworthy source, that there are some serious programs that could basically that are basically now at the moment replacing certain lawyer positions, for example, for confidentiality agreements and checkups, and they perform it. I mean, robots basically perform those checkups much better, with much more accuracy than lawyers, and do it much quicker, and it also can be cheaper. So I don't know, law firms, just as you said, maybe lawyers just are a little bit too far away from IT guys. That's my comment.
Yeah, adding to this comment, I want to say that in Lithuania, I have read in the news that one law firm started already to use this artificial intelligence for M&A transactions. And of course, they faced with the problem how to train to Lithuanian, because it's a, purchased system, but still they are testing, and they hope that it will work well. Yeah, and what I have read also, that in the United States of America, in bankruptcy cases, there are used systems which make a judgment for the court, the judge. They propose a judgment, and the accuracy, if I remember correctly, something like 75%.
So I think it's going to be not only digital economy, but also AI economy, and it's still I think we will need some legal persons to regulate it, but it's going to be very interesting.
Could I just add because it's getting very depressive, and as any conversation about AI, it must end in an apocalyptic scenario where lawyers go and do, I don't know, building work.
No, maybe we'll go, no, building works will be done also by robots, and we will go and party.
Yeah, we will go party. I love that approach. I think that we should maintain the relation that the person controls the technology, not the technology the person. So this is what I may add, so we wouldn't end in apocalyptic mode.
Yeah. For example, like in countries like Lithuania, where we apply principles, yeah. So anyway, for example, we need somebody, human being, to look at the case finally. But it could be a lot of work savings, so why not, even if it's better accuracy? So let's us take more creative, except, you know, for looking these huge files and just think about new ideas. So I think that it's a good way to go. It's my personal opinion. Okay, so thank you very much, and I think it was a very, very interesting conversation, and your presentations were excellent. Thank you very much, and for the audience as well. Thank you.